The 2002 supporters for Siaya were cross-checked as registered voters and yielded 201 as registered voters in Siaya County. Then another finding is this. The aspirant thus met the threshold of 2,000 supporters in at least 24 counties as required. That is a finding. So in his own findings, he says that this applicant has met the signature requirement in at least 24 counties as per Article 137 of the Constitution. That's what he says. Then he proceeds further to now expute prejudice, ill will, hate in a public document. And this will be indelible for memories and reference in the future. That copies of identification documents were not sequentially arranged and numbered. That was the purpose of the letter of 31st. If you had a problem with this arrangement, with the numbering, we asked you on 31st. Invite us, we'll do it for you. But for good measure, those are not legal requirements. Those are administrative requirements. Those are administrative requirements, we could have met them if we sought our engagement. The legal requirement is what is captured in the finding. He has met the threshold of 2,000 supporters in at least 24 counties as required by law. By law. Article 137 of the Constitution. Okay. At this point, that is sorted. I move to the last point now. This is now the crux of this case. At the time of the rejection of this application, the respondent did indicate, and as shown in page 18, application rejected due to degree certificate for candidate not attached, contrary to Section 22 of the Elections Act. And he read for us Section 22 of the Elections Act. Section 22(2) of the Elections Act, if I may read, provides, notwithstanding subsection 1b, a person may be nominated as a candidate for election as president, deputy president, county governor, or deputy county governor, only if the person is a holder of a degree from a university recognized in Kenya. Holder of a degree recognized from a university in Kenya. The respondent reads his own words by saying degree certificate. There is no mention of the word certificate in Section 22(2). That is the operative law. But we expect him to want proof of the degree. A degree is a conferred honor by a university. So you must have gone to school. You must have attended class. You must have done your exams. You must have passed those exams. And you must have concluded your course, the entire course. Then now you have a degree. As I canvass this point, I want to refer this honorable tribunal to Section 3, subsection 1 of the Judicature Act. Let me say from Section 3 of the Judicature Act, which sets out the laws of the Republic of Kenya. It is very important to capture this. Section 3 of the Judicature Act sets out the sources of law in Kenya in their hierarchy. Number 1, Constitution. Number 2, Acts of Parliament. Number 3, received law, comma, common law, judge-made law as a source of law at number 3. Number 4, subsidiary law, delegated legislation. And number 5, customary law. In that ranking, it is important that we capture the ranking of the sources of law in this country. There has been previously a dispute as to the interpretation of Section 22(2) of the Elections Act. And as we resolve that dispute, I urge you, put your finger on the sources of law which I have indicated. In resolving that dispute, the High Court of Kenya was invited in the case of Janet Mbete versus IEBC and two others. 2013 EKLR. The High Court of Kenya was invited to consider what is the meaning of section 22(2). And the High Court said this: I am therefore in agreement with the third respondent that a degree is not a physical connotation, but is a process whose pinnacle is the graduation. It is therefore clear to me that the graduation ceremony cannot be used as a measure to determine whether one has a degree or not. In my view, what matters is that a person has attended school, undertaken the studies envisaged, and has passed all the requisite exams for the conferment of the degree. Having found as above, I am therefore satisfied that the third respondent holds the qualifications envisaged by section 22(2) of the Election Act.
What page of your authority?
That is page, still on the main, or the substantive, it's page 16. Or in the bundle, the main bundle. Page 16 in the main bundle. But that authority is also found in my authorities, page 53. If you go to page 53 of my bundle of authorities, I have highlighted it. And let me say this, Mr. Chairman, honorable members. In the case of Janet Mbete, the case I've just cited, it's on page 53 of my bundle. The IEBC was arguing the position I am arguing today. The IEBC was a respondent defending Governor Joho's degree, completion letters, and transcripts, and recognition by CUE. The same commission was arguing as I'm arguing today. That was in 2013. And the judge agreed with them. The judge agreed with Chebukati. The same Chebukati goes to court, seeks an interpretation of section 22, offers his interpretation, which the court affirms, turns around 10 years later to say that law is bad law, just because His Excellency Jimmy Wanjigi has appeared. And at this time, it was Mr. Isaka's son,
Yes.
who was the chairman of the commission, 2013. And the second authority, and refer you to Mr. Chairman, is found at page 46 of my bundle of documents, my bundle of authorities. And the court, Justice Ogola, frames the issue this way, at page 46, paragraph 11. The issue for this court is then to determine whether or not, after a person has successfully gone through the process leading to the acquisition of a degree, he is qualified under section 22(2) of the Act, even when no physical certificate has been conferred. In my judgment, the respondent has made a very superficial interpretation of section 22. In my view, a certificate is merely a confirmation of what is already in existence. The petitioner has successfully completed the course program. The program has been acknowledged by the Commission for Higher Education. Then he concludes by saying, in my judgment, the petitioner has successfully undergone a process in the acquisition of the qualification required under the Elections Act and the Constitution. That process has been recorded by the Commission for Education, and the respondent has no option but to admit the petitioner to the relevant candidacy. My Lord, Your Honor, is from paragraph, page 46, from paragraph 11 to paragraph 13, which explicitly discusses it. And the court proceeds to order the respondent to admit the petitioner to the relevant candidacy. This decision was affirmed by the Court of Appeal in this matter. On a subsequent election, petition went to the Court of Appeal. So that the law is settled.
Do we have the citation for that appeal?
For the, it was Mabul Muruli versus Oparanya. It was now separate. Now it was challenging the election petition challenging the election. When that issue went to the Court of Appeal, the Court of Appeal said the issue had been settled by the High Court and they did upset. And both these decisions have not been challenged since 2013. So the interpretation of Section 22 is law. So what happened on the 6th of June? Because the same IEBC was a party to all these proceedings. To answer that question, Mr. Chairman and members, sorry, before I go to that point, let me just say this. That these decisions are now binding. They are binding on everybody. They are binding on this tribunal. You are bound by it. You are sitting as a quasi-judicial body. You have judicial authority recognized under the Constitution as a subordinate court. And the doctrine of stare decisis applies. It applies to this tribunal. You are bound by the interpretation of Section 22(2), which was given by the High Court. You are bound. No other court has interpreted Section 22(2) in a different way. And it is not open for this tribunal to change course at this point. Neither was it open for the returning officer to change course when confronted with a similar situation. And I refer, Mr. Chairman and members, to page 15 of my bundle of documents, the case of Mohammed Abushiri.
Bundle of authorities or?
My bundle of authorities. Now I'll be referring to my bundle of authorities.
Page?
Page 16. It's the case of Mohammed Abushiri, Mukulu versus Minister for Lands and Settlements. Where the court affirmed, sorry, page 15, not 16, page 15, sorry, page 15. Page 15 on the second paragraph. In its vertical application, a court is bound by the decisions of a court superior to it. The principle of stare decisis in its vertical application, a court is bound by the decisions of a court superior to it. This is a court. You are bound by the decision of the High Court. That is paragraph 2 from line 3. At page 20, I cite the case of Jacinta Wanjala Mwatela versus IEBC again. The court says that the principle of stare decisis exists to protect the certainty and uniformity that is key in the fair administration of justice. That is, my Lord, Your Honor, at page 20, the last paragraph from line 5 of the last paragraph. At page 26, the case of Okia Omtata versus Attorney General, from the second last line of that page, 26 going to 27, the Court of Appeal or the High Courts are bound by the decisions of the House of Lords, and of course, similarly, the Magistrates Courts or any other inferior court in each state are bound on questions of law by the decisions of the Court of Appeal, and subject to these decisions also to the decisions of the High Court in the particular state. So, this decision of the High Court, these two, they are binding. It is not open to even me, Willis Otieno, to disobey them. I can only appeal them or amend the law. Amend section 22(2) of the Act. Any other law, subsidiary section 22(2), cannot go contrary to these provisions. And in that same case at page 27, the court cited the case of Jasbir Singh and others. The Supreme Court of Kenya is being cited where they say, adherence to precedent should be the rule and not the exception. Page 27 of my authorities. If you look at paragraph 15,
15.
he's citing the Jasbir Singh case, the Supreme Court decision of Supreme Court of Kenya decision, where the Supreme Court of Kenya said, adherence to the precedent should be the rule and not the exception. We must always adhere to precedent. Public officers, subordinate courts and tribunals must adhere to precedents established by the High Court, the Court of Appeal, and the Supreme Court. That is the rule. It can't be the exception. So what happened? In light of that settled law, honorable members are to submit.
So, Tim,
Yes.
you have precisely 10 minutes.
If I can ask for 20, I'll be very grateful.
No.
Because, you know, Mr. Chairman, it's a matter of life and death.
No.
This is a matter of life and death.
No.
Just allow me. I know I'm pushing you, but just allow me.
You know, we have to give you a decision.
Okay, let me try. In case let me just
We
try.
can sit and listen.
No, let me try to be fast. Within
10
the
minutes.
Let me try.
Ruth,
So what happened?
please start the time.
Let me try. What happened? The chairman made a decision per incuriam. In arriving at his decision that he wanted a certificate, he was speaking per incuriam. He was speaking in ignorance or lack of knowledge of the existing law on section 22(2). He didn't have the benefit of knowing what the courts had said. And I refer to page 57 of my bundle, Anyasi Olusese versus Standard Limited, page 57, Your Honor, where the court says a decision is given by incuriam in ignorance or forgetfulness of the existence of a case or statute. So the chairman may have gave his decision without having in his mind the existing High Court decisions interpreting section 22. And at page 7, the court says, what is meant by giving a decision by incuriam is giving a decision when a case or statute has not been brought to the attention of the court, and they have given the decision in ignorance or forgetfulness of the existence of that case or that statute. So Mr. Chebukati, in all fairness to him, was not aware of the Mabulu case, was not aware of the Janet Mbete case, or he forgot. He made a decision by incuriam. So now that we've brought it to his attention through this tribunal, that decision is binding. That decision that was made by incuriam must be recalled, and the orders we are seeking granted. And my Lord, Mr. Chairman, let me say this. At the time when Mr. Chebukati cleared Walter Nyambane, earlier, I think on the 31st, he was applying this same law. his officers must have been aware of this same law. That's why they cleared him. And the facts in Walter Nyambani's case sits on all fours with the facts in this case. Same university, same qualifications.
Are you calling upon what happened to Walter Nyambani?
Yes, I'm coming to that.
As an authority?
So I'm saying, no, I'm saying that was the law when it was cleared.
Yeah.
What happened subsequently is a decision by incurium.
Mr. General, argue your case.
Let me continue.
Yeah. So you know how that one ended?
No, let me continue. Let me continue.
Argue,
So I'm arguing on point. Let me continue. Let me just, by 10 minutes,
Yes,
Mr. Chairman. So that, having established the existence of a superior court decision interpreting section 22, it is now onerous on the chairman, the returning officers, and this tribunal and the commission to apply the law as decided by the High Court. The respondents have purported to cite Regulation 47. In brief answer, I will say this. Section 57 of the Interpretation and General Provisions Act specifically says a subsidiary legislation cannot be inconsistent with a statute. Regulation 47 is a subsidiary legislation. It cannot supersede the provisions of Section 22(2). And that argument should fall. We should not even engage in it. But for good measure, let me even explain. Regulation 47. Regulation 47 does not set out the minimum qualifications for candidates. It is not a statute that sets out the qualifications to be met by candidates. The qualifications are set out in Section 22. Regulation 47 merely prescribes that documents must be certified. It gives advocates work. That whatever you are presenting to the commission, you must certify it as a true copy of the original. And to read it, it specifically provides certification of educational documents. That is the language of that regulation, certification. That whatever document you are submitting, educational certificates you are submitting, they must be certified. That is the provision.
Regulation
47.
7, sub-regulation what?
I think it's regulation 47 too. Yes. Of the election of general regulations. So that the respondent cannot rely on the provision of a regulation. Sorry, maybe my time can wait for 1 minute as the chairman sorts himself. I want to preserve my time.
Proceed, Mr. Otieno.
It says this, let me read it. Ascertainment of a qualification. It's Regulation 1. For purposes of ascertaining the educational qualification, the commission is told to ascertain. They are being sent to the respective bodies. A person seeking nomination shall submit to the commission certified copies of certificates of the educational qualification for purposes of ascertaining. So that when we submit to you a letter from CUE, we certify it because you are going to confirm with CUE to ascertain if it came from them. when we submit to you a letter, a completion letter from the university, it must be certified for you to go and confirm that it has come from the institution. It does not impose an obligation on the minimum qualifications to be a candidate. The qualifications are set in Article 137 and further qualification in Section 22 of the Elections Act. So you cannot use the regulations to oust the provisions, and I want to rely on the latest authority in town, issued by the IEBC Dispute Resolution Committee in the case of Jimmy Wanjigi, and Mr. Chairman, I wish this to be noted down, versus Wafula Chebukati, case number 86 of 2022.
DRC versus
Jimmy Wanjigi versus Wafula Chebukati, case number 86 of 2022, where the tribunal, in its own ruling, asserted the supremacy of the Constitution as overriding the provisions of a regulation to hold that Regulation 17, which calls for cross-examination of witnesses, flies in the face of the provisions of the Constitution.
Proceed.
Article 252. I want to cite that authority, and I wish that to go on record, Mr. Chairman.
I've already recorded this. Proceed.
I'm concluding. That was my last. That's my last point. I was making my last point. So in light of those submissions, I do pray that this tribunal do allow the complaint and find against the respondent and direct that the complainant's name be included in the name of presidential candidates and a certificate of nomination be duly issued to him within the shortest time possible, probably on the 18th. We propose the 18th of June 2022. A further delay will occasion us to lose campaign time when we should be talking to the people of Kenya. Thank you very much, Mr. Chairman. I've left you 1 minute, which I've donated to you. You can donate to Mr. Kugei.